All right. So the consent form that I'm going to be basing this off of is from Olive Branch Counseling and Training, which is based out of Texas. Um, this consent form, I'm just going to go through some of the main highlighted areas of what was discussed within it. It did start out with the background of the counselors, the type of licensure that they hold. And they do talk about like the code of ethics and why it's important for them to not only abide by the code of ethics, but talking about why they're in place and why they are there to protect the client. I really like that about that section because some of the other ones that I did read didn't necessarily talk about that. So I kind of like how it incorporates the protection of the client because we are about the welfare of the client. It did also talk about the certifications and their philosophy. So what I liked about the philosophy section is they did talk about the wellness model and why they like the wellness model over the medical model and focusing on what is already going right for the client and helping them utilize tools and such that is necessary and the type of techniques and interventions that they do like to use to help the client move forward in their journey. They also did talk about the relationship. Something that really stuck out to me in this section is they did talk about like what is appropriate communication between counselor and client and what is not. So they did bring up the kind of more confidentiality within this. So if like a counselor were to see a patient or client out in public, that they're not going to approach that person, but if that person would like to approach them and go about communication, then they're more than welcome to do that. But in regards of keeping that confidentiality, they will keep that distance unless the client does initiate that interaction. They did go over the risks and benefits of counseling, and they did talk about speaking, openly and honestly, and that the clients who tend to do that are usually see more progress moving forward. They also did go over working with minors. So, something that they do in the state of Texas, they do like to involve both parents within counseling decisions if it's a minor. So, unless a parent has, what was the term that they used? Exclusive rights. If one particular parent has an exclusive right for that minor, then they will only contact that parent. However, they still do like to contact both parents if it is okay with that parental party. They just feel that having both parents involved in their child's wellness is important. And they also did bring up how they like to talk to parents about the importance of the counselor keeping the confidentiality with the minor, because that is very important with minors just like it is with adults. Keeping that confidentiality and not breaching it unless it's absolutely necessary. They did mention, parents have the independent right to know what is going on with their child within those counseling sessions. But however, they do like to keep this confidentiality. They will keep them informed as to what is going on. And if it's absolutely necessary, they will let them know. But if it's something that can be kept between counselor and client, that is to do so. And then something that was kind of interesting also, if they do turn 18 years of age during their counseling with the counselor during their sessions, there is a new form that has to be filled out. And then once that form is filled out, that parent no longer has to be informed of that child's counseling decisions. So they're now 18 years of age and adult. So it was kind of nice that they talked about that as well. The confidentiality, again, they talked how it's important between counselor and client. However, there are outstanding scenarios as to why confidentiality will be breached and without the permission of the client. So what they did list here is confidentiality does not apply to cases of suspected abuse, neglect of children or the elderly. It does not apply to cases of potential harm to self or others. Mental health professional may disclose confidential information in proceedings brought by a client against a professional. It may not apply in cases involving legal proceedings affecting the parent and child relationship. And it may not apply in cases involving the minor child. In such cases, the counselor may advise parent managing conservator, or guardian of a minor with or without the minor's consent of the treatment needed by or given by the minor. So I like that they definitely showed clearly, like, these would be the reasons I would breach it without your consent. They also did go over payment. Talked about how it kind of would work with an insurance company and calling your insurance company before you go if you plan to not be private pay and use your insurance, and that there's usually co-pays and you usually only get a certain amount of sessions. So they did talk about needing to contact your insurance company, figure out that amount of sessions and how you would like to pay if you want to use your insurance or if you want to be private pay. They did talk about if for some reason the payment does not go through, like a credit card decline or something, they will sometimes call the client and they will let them know that it didn't go through, and that's more of a courtesy. But for future appointments, they won't be scheduled or anything until payment has been made, and an alternative mutual agreement between counselor and client has been made as well. They did go over electronic records, and how they maintain all of their stuff. So they did talk about a little bit of the technology that's used to maintain those, and the health information privacy policy summary. So that's kind of what this all went over, obviously with the signature at the bottom. Overall, I thought it was a pretty well maintained and put together consent form. It covered a lot of areas. It definitely covered a lot of what the ACA suggests. The ACA wants you to make sure you talk about your purpose and your goals, techniques, risks and benefits, which they definitely covered. The qualifications and credentials of the counselor and the relevant experience and their approach, they covered that. The continuation of services upon death of a counselor. So they didn't go over that, which that was one thing that I don't really... Is that something that is normally... That is one question brought up. Is that something that's normally in a informed consent? Or... I don't know. It just seems something... I mean, I understand it, but it seems something kind of a little odd to have an informed consent. They also wanted you to make sure you went over... you had the proper steps to ensure that the client understands the implications of diagnosis and intended use of tests and reports. So they did not talk about that, but another question that kind of got brought up to me when reading this is, do all of these areas need to be written within a written consent form, or can they also be part of what they have to do verbally? Because I know a counselor is responsible, both written and verbally, to go over informed consent with a client. So I don't know if some of these, that's a big question I actually have, do they all have to be within a written consent form, or can they be kind of that portion that is discussed with a counselor? Inform the clients of fees and billing arrangements, that was in there. The confidentiality, that was in there. And it also says to obtain clear info about the records, patient records, ongoing counseling plans. So making sure like the client is still involved within their counseling plans and their records and they have access to them. That was not in there, but again, is that something that can be kind of included within a verbal discussion of this? It also ran very close to Florida. Florida does follow the ACA pretty closely with their informed consent. They did mention in theirs talking about like the approximate length of care and how the treatment will be monitored. So like I said, neither of those were in there. That's something that I don't really know could really be in a confidentiality or informed consent agreement. I feel like that might be more of like a face-to-face type of conversation. So that's something that I am curious about, like what actually needs to be within that form and what can be told verbally. They also, Florida talks about the consent may be revoked orally or written by the person who's authorized to do so, so whether a minor or an adult, whatever that situation calls for. And they did talk about needing to make sure that that client is aware of what can potentially happen if you revoke that and not continue with treatment. And I believe that's it. So I guess my biggest question that I was really left with is, do all of these sections, especially what the ACA covered, does that have to be in that form, or can that be something that is verbally talked about and agreed upon? I don't really obviously know how that works. So that's something that I'm definitely curious about. I do like, though, overall, their whole form was very detailed. It's actually a pretty long informed consent. So yeah, it's pretty lengthy. Went over quite a bit, so I'm very curious. Like, does every single one of those topics have to be in there? Can it be verbally talked about instead of being on the paper, or do they have different forms for those? I don't know. So that's definitely my biggest thing that I have a question on, and my biggest takeaway. I thought overall that this form was covered most of the important areas I feel like that need to be covered, especially when it pertains to confidentiality and the fees and so on. So, all right. I hope you guys have a wonderful day.